So there's much to discuss. And of course, last but not least, is the legal issues that are becoming larger and more urgent by the day. There are Israeli ex and current military officials that are being targeted by various NGOs, certainly in Europe. So there's much, again, to discuss today, and we have an incredible program for you. So without further ado, Mark, the floor is yours to introduce our topic and speaker. Thank you.
Thank you, David, and hello, everyone. Welcome to ELNET's Monday briefing. Before I introduce our guest, Natasha Hausdorff, I'd like to provide an update to our format today for question and answers. In order to get to more of your questions, we have decided that instead of turning over the mic to you, we're going to ask you to submit your questions to us, and I will credit the person who's asking the question, but I will read the question on your behalf. We found that this will save a lot of time and allow us to get to many more of your questions. I'll remind everybody of that as we get to Q&A. So now to introduce Natasha. Natasha is a well-respected and renowned expert on international law and the use of lawfare. After receiving her law degree from Oxford University and an LLM specializing in public international law and the law of armed conflict from Tel Aviv, Natasha clerked for the president of the Supreme Court of Israel in Jerusalem. As a Pegasus scholar, she was a fellow at Columbia Law School in the National Security Law Program, and she lectures globally on aspects of public international law and national security policy. She is the legal director of UK Lawyers for Israel Charitable Trust on a voluntary and pro bono basis, and she speaks for Israel on a pro bono basis. Ms. Hausdorff is a frequent contributor on legal matters for international media and has participated at several public debates about Israel and Zionism. She regularly briefs politicians and international organizations and has spoken at parliaments across Europe and the United Nations. So welcome, Natasha. I'm bookended between a heavy subject, the fires in Israel, in California, and what's going on in the Middle East, and certainly this topic of lawfare. So I thought, Natasha, I was going to open with a little levity by making a quick joke with a play on words, particularly to the American audience. And the warning was not to confuse a barrister with a barista. Now, interestingly, I happened to go to Wikipedia to actually learn what a barrister does. And I kid you not, below the word barrister in italics was not to be confused with a barista. So I want you to know, now that I know the difference, I will not be ordering a cappuccino with extra foam, extra shot. So with that, again, thanks for joining us, Natasha.
It's my pleasure. You perhaps won't be surprised how many people are confused by that terminology. And the fact of the matter is I do make some great coffee too.
All right, I'll take you up on it at some point in the future then. I'd like us to level set this discussion by asking you to define lawfare. And perhaps if you could, give us a cursory example of how lawfare is applied against Israel, the different ways.
Sure. Well, my definition of lawfare, if I may be permitted to start with that, is as an abuse of law, of international law in particular, vis-a-vis Israel, of international legal institutions and international legal processes. I see this, in fact, as the weaponization of international law against the Jewish state. And while there will often be appropriate applications of law domestically and internationally, what sets lawfare aside is it's not a proper application of law. It's, as I say, the abuse of legal processes to pursue a particular legal agenda. Now, I fully accept that the term is used in different contexts and has certainly been adopted by different organizations to mean slightly different things. But when I use the term lawfare, it is not to refer to any proper practice of law, but as I say, to its manipulation, but also its misrepresentations, because looking at the way that the law is so often misapplied to Israel, and perhaps answering the second part of your question, it's not just the legal processes that are being weaponized against the Jewish state, but it's also their public coverage of them, in which many of those legal processes, and I'm sure we'll come on to discuss the ICJ in particular, the International Court of Justice, which sits in The Hague, is the court that deals with disputes between states. Some of the ways in which the proceedings brought against Israel have been represented in the international media compound the lawfare approach by misrepresenting even what this court has so far determined vis-a-vis the Jewish state. It's an increasing phenomenon and an increasing trend. It's definitely now on people's radars far more so than it was in previous decades, but it has been with us for some time, and I hope we'll have a chance to properly unpack some of the ways that it's been developing over a number of decades.
Is it applied only, or let me say it this way, is lawfare applied only to Israel? Is Israel the only country that suffers from the application of lawfare, or is it just a matter of degree? It's applied to other countries, but it's applied in a far greater degree towards Israel.
Yeah, it's certainly not only applied against Israel, but the most severe, significant manifestations of it are certainly against Israel. But vis-a-vis the UK, I think we can also see certain proceedings concerning the Chagos Islands. I don't know how many lawyers we have on the call, but some of the audience may be aware that there was an advisory opinion sought with respect to the Chagos Islands, which is quite an unusual and many would argue inappropriate approach to take. An advisory opinion is a process which the International Court of Justice also conducts, but it ought never to engage in providing an opinion of that nature on an issue where there is a dispute between states. In that case, that dispute involved the United Kingdom. And I think there's a strong argument to say the UK's rights were ridden over roughshod to have the ability to determine where and when a dispute of that nature is considered by a court which has jurisdiction. So that's just one relatively recent example. But the reason that understanding the true manifestations of lawfare against Israel, I think, is so significant is that it has repercussions for other states, really significant ones. The more we see international law being thrown out of the window, the more susceptible other Western liberal democracies are going to be to these sorts of political attacks in these weaponized pseudo-international law institutions.
And we're going to get to that in a little while because you raise a very interesting point. I wonder what the obligation of states will be to push back on the ICC in order to maintain credibility in the rule of law. But I'll get to that in a moment. I want to discuss the idea of lawfare as a subset of idea laundering, and idea laundering being defined as the hijacking of legitimate words, ideas, or phrases to infiltrate into the marketplace of ideas illegitimate, fabricated, or distorted ideas. And if that's the umbrella, lawfare through the ICC, ICJ, and UN could be a form of disseminating that. But we also see it in the majority of interactions which are not legal. We see it on social media. We see it on the media. We see it in debates like the monk debates that you and Douglas Murray were involved in with Mehdi Hassan and Gideon Levy. There's this discussion about very important words that have legal meanings like genocide, proportionality, occupation, borders. Could you talk about the interaction between the public sphere that engages in these legal gymnastics, defining these words, and then the legal world? You sit atop both of them. So how do you see them interacting?
Well, there's an additional area here, and that's the academy. And so far as international law is concerned, the academy has actually played a significant role in this laundry of words and the weaponization of these legal terms that are being deployed for political purposes. I think in the monk debate, I gave an example of a number of them. I'm not sure that I mentioned occupation, but I would definitely include that in a list of pseudo-legal terminology, which is being misdeployed with respect to Israel for a particular purpose, so occupation, ethnic cleansing, colonialism, apartheid, and genocide. In each of these instances, not only is this legal terminology that is being wholly inappropriately applied in, I would say, all of them, the concept is actually being inverted. So we have the victims of a particular phenomenon, all of them issues in international law, that are being accused of committing that act or crime that was actually committed against them. And nowhere is this more apparent than in the context of genocide. And I can say shortly after, I think it was the day after the first provisional measures order came out from the International Court of Justice, this was on the 26th and then 27th of January last year, I was on the equivalent of the BBC in South Africa, SABC. And my counterpart, who was arguing the case for South Africa, bringing this abhorrent, obnoxious, totally baseless accusation of genocide, said something along the lines of, "Isn't it wonderful? Now we can finally use Israel and genocide in the same sentence and nobody can tell us otherwise." And that was a clear acknowledgement, as far as I was concerned, of the motivation of using these sorts of terms and then using the legal mechanisms, the legal processes, which shift the Overton window and suddenly give something that is entirely baseless and fantastical some degree of supposed credibility in the conversation and the discussion. And it's a vicious cycle and it's self-perpetuating, because the more that people are talking about Israel and genocide in the same sentence, the more credence that South Africa's application seems to be given. And now most recently we've had the intervention of Ireland to, in fact, it's been quite upfront about the fact that it is seeking to extend to amend the definition of genocide so as to try and better shoehorn what it says Israel's actions are into it. It implicitly acknowledges, I would suggest, therefore, that it does not consider Israel's activities to, in fact, be genocide, or the crime of genocide. But we're seeing this approach to weaponizing legal terminology and abusing it in this way, I think, across the board. And I think one of the reasons that these negative actors have been able to do this so successfully is that general literacy about international law is not particularly extensive. And most people, when they hear international law or international legal terminology or the allegation that Israel breaks international law, don't feel armed with the tools, with the knowledge, the expertise to be able to properly push back on that. And we're seeing this manifesting itself at every imaginable level. So yes, at the United Nations and international legal institutions, in the academy, in the media, on social media, in schools, and TikTok, and probably in the workplace and at the water cooler. And there becomes this, generally accepted, received wisdom as a result, which is totally divorced from the reality, the facts, the law. But if you don't subscribe to it, suddenly you are the other. And absent the ability to properly explain why you don't subscribe to it, and perhaps even convince others that they have been entirely hoodwinked in this situation, I can entirely understand how it just becomes this, snowball. I think it's even more important that we do our utmost to counter it in those circumstances.
You mentioned the ICJ, so I'm going to jump ahead and ask a question about the ICJ and the two cases. So I heard you in a prior interview, you explained that the ICJ, the International Court of Justice, is having the responsibility of either offering an advisory opinion or a binding resolution of a conflict between two states. And I'm sure there are many questions, but around that phrase, two states, but I have two. The first one, in the context of Israel and the Palestinian territories, does the ICJ see two states? And for the two cases brought before the ICJ, the one brought by South Africa against Israel and the one brought by Nicaragua against Germany, what legal standing, if it's between two states, what legal standing does a third party have to bring a case on behalf of one in which it has it's two standard deviations away from the conflict. What legal standards do they have to do this?
So the first thing is I can appreciate why this feels anathema and somewhat complex or alien, but the simple explanation that I can offer to the cases that you have outlined is the fact that if states are party to an international convention, they may bring a case or a claim or an accusation against another state in respect of that convention. So international conventions are signed up to by states. They are an important source of international law. It's a treaty-based. It's almost like a contract that you sign yourself up to. But here we're primarily talking about the Genocide Convention, the International Convention for the Prevention and Punishment of Genocide. And that is the legal hook that South Africa has used to bring Israel to the ICJ, the International Court of Justice, because both Israel and South Africa are signatories to the Genocide Convention, and South Africa is alleging that Israel has breached it. That's the jurisdictional basis for the bilateral dispute that you have seen all over the media in terms of South Africa's allegations against Israel. I mentioned that Ireland had recently joined that case as an intervener. That's entirely possible because Ireland is also a party to the Genocide Convention. And the idea behind this is that every state party is responsible for seeing the proper enforcement of that convention. Now, this is particularly interesting because my argument right at the very beginning of this war, long before South Africa had brought this case, is that every signatory to the Genocide Convention had an obligation to ensure that the genocidal acts of the 7th of October were punished and prevented, and therefore had an obligation to ensure that they were supporting Israel in every way to seek the total eradication of Hamas, the return of the hostages. That didn't particularly go very far. I mean, there are many international law obligations deriving from conventions that I'm afraid are simply not complied with. And now, of course, many of our viewers may be familiar with real genocide that is currently occurring in South Sudan. Many aspects of real breaches of international law are simply not picked up on. That is one of the big criticisms of the politicization of international law. But I hope that explains why it is that South Africa can bring this particular claim, this allegation against Israel. In terms of this idea of two states, this is the buzzword two states, of course, that applies in the context of the received wisdom of what the quote unquote only possible solution to the Middle East conflict must look like. Perhaps there'll be an opportunity to try and unpack the misguided received wisdom in that respect in due course. But it's difficult to say where either the ICJ or, for that matter, the ICC, which is the International Criminal Court, also sits in The Hague, but it deals with individual criminal responsibility. So it's not, in fact, dealing with states. But both of them have recently taken rather confused positions with respect to this question of whether there is a state of Palestine. So moving away from what a political resolution might look like and concentrating on what the current legal position is in terms of two states, it is clear, if you consider basic international law and the requirements of statehood, which are also set out, they're a matter of customary international law, but they're also set out in the Montevideo Convention. There isn't a question in my mind that there is no such thing as a state of Palestine. It does not fulfill those criteria, not least that there is a division between Fatah in the West Bank, whose authority there is governed by the international agreement under the Oslo Accords. Obviously, Hamas has controlled Gaza. It still controls significant parts of Gaza. So the idea that there is a coherent government simply doesn't exist. There are no fixed borders. There are big problems with respect to the idea that Palestine presents itself as a state just because you use the State of Palestine stamp at the bottom of some official documents. I'm afraid it's not enough. There are, of course, increasing numbers of states that have recognized the so-called State of Palestine. That's also not sufficient in international law. There's a big debate about recognition. It plays some significant role, but it cannot compensate for where the basic attributes of statehood are missing, as they are in this case.
It's all very interesting, and yeah, it's very nuanced and complex. So thank you for that clarification. So for my next question, as a preamble, I want to read something from a research paper at University of Pennsylvania that I came across with regard to the ICC, the International Criminal Court. The goal for the ICC was to establish a permanent, independent court to investigate and bring to justice individuals who commit the most heinous violations of international law and human rights, namely war crimes, crimes against humanity, and genocide. Of the thousands of situations and potential cases that could have been investigated by the ICC and come to trial, only 44 people have been indicted, with 45 cases before the ICC. Further, only 14 out of the 45 have resulted in a complete proceeding, and only 9 were convicted. 9 in 23 years. So given the court's, and I'll use this word, but I'll leave it for you to tell me if it's correct or not, failures, bringing despots and ruling thugs to justice, why do you think they decided, the ICC that is to go after Netanyahu and Gallant? Is it as simple as, oh, go ahead, I'm sorry.
No, I think it's perfectly clear why. And I would add abject to your description of failures. This is a court that has abjectly failed to live up to the lofty aspirations of its founders. In its first 10 years, only one of those convictions had in fact been achieved. One successful prosecution had been brought at the cost of nearly $1 billion US. The failures of this court have not escaped public attention. It has come under resounding criticism, not just in terms of the money and lack of actual convictions, but also because it is, for the vast majority of its time of operation, almost exclusively focused on African defendants. So there were lots of allegations of racism against the court as well. And then in 2020, there was an independent expert review of the court, report of some over 600 pages, called out an atmosphere of fear and intimidation at the court. I mean, it really couldn't have been worse in many, many respects. What better way to rehabilitate yourself, to cleanse yourself and come out as the good guy, than by going after the world's punching bag and the Jewish state? To me, it seems pretty apparent when the investigation concerning Israel was first opened in 2020. Remember, that expert report was also published in 2020. It was only a matter of months after the findings of that report were made public. The application from the former prosecutor, Fatou Bensouda, was made to Pretrial Chamber 1 to open this investigation. The prosecutor before her had declined on the basis that he didn't think that there was sufficient jurisdiction. It's important to understand that jurisdiction is what separates a legal institution from a political one. And the jurisdiction of the International Criminal Court derives from its members. States that sign themselves up to the court delegate their own jurisdiction to the court. Absent that, we've already talked about the fact that Palestine isn't a state, so it cannot sign up to the ICC in the first instance. But even if we were to ignore that, as the court has done, the idea that it would be able to delegate criminal jurisdiction over Israelis to the court, which is what it is purported to do here, is also entirely unworkable when the founding document of the Palestinian Authority, which is the entity that purported to join the ICC, the founding document, which is the Oslo Accords, makes it explicitly clear that no criminal jurisdiction over Israelis will be afforded to the Palestinian Authority. And there are a number of states that sought to raise this problem with the ICC, and with Pretrial Chamber 1 in particular, that there was an absence of jurisdiction under the court's own rules and practices and the Rome Statute, under the Oslo Accords, that the application that Karim Khan brought was in fact in breach of the rule of complementarity, where the court ought to have in any case allowed Israel every opportunity to investigate and prosecute any credible allegations. It's my firm position that the allegations that the prosecutors brought through to the court are not credible. And the reason that I say that is because the organization that I'm very privileged to be involved in, UK Lawyers for Israel, is the only entity that actually went through chapter and verse the public summary of the prosecutor's application for arrest warrants, which he issued on the 20th of May last year. And we showed that every phrase of every sentence of that public summary was false, and gave the prosecutor every opportunity to address the fact that he had misdirected the court, he had misled the court, he had put in front of it false information, and not only did he not take that opportunity, he in fact doubled down and told the court to ignore any submissions on accuracy that came from anyone other than him. This is the level, I'm afraid, of malpractice that we are dealing with at the International Criminal Court. But I hope that gives a little bit of a flavor and an indication of the magnitude of the problems that one faces in the context of this international legal institution, and how the recent behavior and conduct has been intended, I believe clearly, coming back to your original question, to wash itself of its past failures, but has in fact served to fundamentally undermine its very existence by throwing international law out of the window, by throwing jurisdiction out of the window, its own rules on complementarity, and putting forward this totally false information. It's, I believe, damaging its reputation beyond saving now.
Yeah, I didn't want to be accused of asking a leading question, so I didn't say, do you think it's politically motivated? But I think at the end of the day, this is highly politically motivated for any number of reasons. I want to turn back to idea laundering a little bit, broadly speaking. So, and at the UN. So I'm going to apply the idea of idea laundering and now lawfare to the UN. I think I heard you talk about, in fact, I know I'd heard you talk about a 2011 article that seemed to have struck you. And in that article, you mentioned that Abbas sought to internationalize the conflict as a legal, not just a political matter. And to you, that was a declaration of lawfare. Now, I'm sort of curious why that is the moment in time where the flag went up the pole, to raise that alarm. Mix my metaphors, because no doubt lawfare has been applied for decades. UN Resolution 242 and the definition of borders has been mischaracterized. The Fourth Geneva Convention and the movement of populations by occupying powers has been mischaracterized. And most recently, back this September, the UN General Assembly's resolution against Israel, where it relied on the recent ICJ advisory opinion. So we have decades of lawfare. What was it about that moment and Abbas's comments to kind of internationalize that conflict struck with you? And could you tie it all together? Because it has a long history and it seems to have an evergreen future.
Absolutely. Your point about this being a long-running phenomenon is absolutely correct, and a very important one. What Abbas was writing about in the New York Times, what was preceding the Palestinian Authority's latest attempt at that point to join the United Nations as a full member, with the stated intention of essentially leveraging that position and membership of various international bodies, institutions as a result, to conduct this campaign of lawfare throughout all of them. And so it has absolutely been conducted on behalf of the Palestinians by the bloc of Arab states, significantly at the UN. But this was, in particular, I think, the Palestinian Authority leader, he's just gone into his 20th year of his 4-year term, saying this is our new policy. In terms of, the weaponization of international law and international legal phraseology, this goes back to Zionism is racism, which has had a particular international law status in the context of conventions to combat racism internationally. So absolutely, it has been used by detractors of Israel for a significant period. But we can see a significant shift after 2012, when the so-called State of Palestine was admitted to observer status, that it has sought to leverage lawfare activities in a far more concerted way, and done so with the support of armies of NGOs that have been established particularly for this purpose. And it is so pervasive that now, formerly respected NGOs like Amnesty International and Human Rights Watch have entirely jumped on this bandwagon of a relentless, obsessive fixation with Israel and the generation of false allegations against Israel and against Israelis. And the two kind of recent big examples of that are in the context of apartheid and genocide. And in both of the reports on these topics by both of these organizations, they very blatantly had to manipulate the facts and the law of what they were discussing. So, for example, with respect to apartheid, Human Rights Watch, I believe in the first sentence, it's clear that they are essentially conflating the local population of the Palestinian Authority, who have self-governance under the PA, with the population in Israel. They consider Arabs and Jews from the river to the sea, entirely fudging the political reality that exists there, as well as the legal reality, in order to seek to justify this incorrect claim of apartheid. Similarly, with respect to the genocide allegation, we have seen a rewriting of the crime of genocide, something that's actually made pretty explicit in the report that Amnesty International put out. It was a precursor, perhaps, to Ireland's application to the ICJ to reformulate the crime of genocide for Israel's benefit. But that is a phenomenon that has, I think, in particular, exploded since this became an official policy of the Palestinian Authority, around about that 2011, 2012 mark. And we have seen the impact and the effects of it.
I want to turn to some remedies now, because obviously, as an organization that works with European members of parliament, educating them on the issues, we'd like to also talk about ways to resolve important issues. So let's turn back to the ICC for a moment, because I want to offer you a syllogism, and I want you then to tell me if it's a false syllogism or it's one that you agree with. In either case, tell me why. So the syllogism is that, one, the court was politically motivated, or because the court was politically motivated, first premise. Two, the court's ruling was legally tenuous at best, legal malpractice at worst. Countries have a moral obligation to resist the ICC, at the very least to ensure the court's legitimacy and credibility, versus the alternative would be just following rules. We're signatories to the Rome Statute. We need to fall in line. But the syllogism is, because the court was politically motivated, because the ruling was legally tenuous, therefore countries have a moral obligation to resist the ICC.
I would say a legal obligation also, if they are, as so many of them profess, committed to the rule of law. I think it's extremely important. The international law is so very unlike domestic legal systems, where there is a proper enforcement mechanism. There are, the legislature will be the source of it. Perhaps you have judge-made law in the common law system, but inevitably, the international legal system is far more nebulous. I remember when I was at university, my professors told me that most states adhere to most international law most of the time. And that is why it was considered to be a net positive. But it ultimately requires states to take on the sorts of enforcement mechanisms themselves. And holding international legal institutions to account when they go off the rails is part and parcel of that. So in respect of the ICJ, the president of the court, Judge Salam, there's some talk of him now throwing his hat in the ring to be Prime Minister of Lebanon. He was formerly Lebanon's ambassador to the United Nations, and his virulently vicious anti-Israel track record there ought to have barred him from perhaps any judicial office, but certainly one in which he was judging issues which he had already very publicly professed a very strongly held opinion on. He called Israel a terror state and accused it of war crimes, and he has, by all accounts, been driving through not just South Africa's case against Israel alleging genocide, but also the advisory opinion which you've referenced, which absolutely was picked up on by the General Assembly in the last United Nations GA in September in New York, but it was a case. It's not a legally binding advisory opinion. Let me just make that clear, as opposed to that track of state-to-state disputes where a ruling would be binding. An advisory opinion is simply worth as much as the quality of the reasoning that went into it. And if you read the dissenting opinion by the vice president of the court, Julia Sebutinde, that will give you a flavor of how little regard I think one should have to the reasoning that went into the majority's opinion. It was an opinion that called for the ethnic cleansing of East Jerusalem and Judea and Samaria. It was an opinion that essentially wiped Israel off of the map when it referred to Palestinian territory as contiguous. And this is the quality of what is being put out under the auspices and the leadership of the president of the court with his, as I say, fiercely anti-Israel track record. In any other context, there would be an expectation that a judge of that sort recuse himself. And it is ultimately the responsibility of member states of the ICC and also of the ICJ to hold these institutions to account. Otherwise, they are a law unto themselves. And so far as they are overtaken by those with an anti-Israel agenda, and this is, I'm afraid, somewhat inevitable. I mentioned the importance of the academy here. The academy has been a space which has...
Could you tell everybody what the academy is?
Of course.
I did have a question about that, so yeah.
Academics and anyone teaching at university, writing. In fact, in the context of international law, one of the sources of international law, which is set out by the statute of the ICJ, includes the writings of the most respected jurists of the age. So academics have a very important role to play in the development of international law and arguably also in its formation. And you can see when I was at Columbia Law School as a fellow, Sarah Cleveland was teaching there as a professor. And I audited some of her classes, and I was not left under any illusions as to what her politics were in the context of that teaching. She is now sitting as the American judge on the ICJ. Many of those serving at the ICJ have academic careers behind them, and there is this back and forth. And in that respect, the takeover in the universities, the fact that anyone who hasn't drunk the Kool-Aid on Israel is never going to get appointed to assistant professorships and professorships and never going to get tenure because they haven't got the right views on Israel, has this self-perpetuating effect of channeling what is with the received wisdom and acceptable to write in terms of commentary on international law, and that inevitably then impacts on how international law is dispensed, if you will, at these institutions when these individuals go and serve as judges on them. So in that context, rather than these institutions being a law unto themselves, it is absolutely necessary that states hold them up. And at least in the context of the United States, I think we are now seeing the political will. Important to stress, of course, that the US, as Israel, is not a member state of the ICC. the court has no jurisdiction vis-a-vis the US or Israel. And the reasons for that are also significant. It was pretty plain, even at the drafting stage of the Rome Statute that founded the ICC, that this was going to be a court that was going to be used as a political weapon, due to some of the drafting of the crimes, including one issue that you referenced earlier, Mark, the supposed crime of Israeli settlers living in Judea and Samaria, Jews living in parts of the world where they apparently shouldn't be living. That is predicated on, in fact, so far as the Rome Statute is concerned, on a tweaking or a manipulation of Article 49.6 of the Fourth Geneva Convention. And also it is unfortunately founded on a total misapplication of international law as far as the status of the territory is concerned. But in any event, we see these sorts of manipulations and agendas coming from various directions. And the significance that the academy, that universities, professors have in shaping international law, I think makes it even more significant, even more important, that the politically elected, democratically accountable leaders of Western liberal democratic states that prize the rule of law take the initiative and ensure that these institutions are not stepping out with their rules, their jurisdiction, and the proper application of international law.
Got one more question, and then I'm going to start reading everybody else's questions. We do have a number of questions on the list. If you do have a question, though, please submit them to us. So, Natasha, for those who care about Israel a lot, as we all do, it's understandable that we focus on the kinetic threats and the very real existential threats that many of these kinetic threats present. But an underappreciated existential threat is lawfare.
Yeah.
It's inch by inch. It's year by year. It's insidious in the way that it develops. It's the ripple that occurs 1,000 miles away and becomes a tsunami that becomes almost impossible to protect against. Where do you see, and before I ask this question, it can't just be resisted by UK Lawyers for Israel or Sharat Hadin or the Lawfare Project, but it seems like that's where much of the effort is coming from. Where do you see this trend going, and how do you think we are ultimately going to resist it with any real effect?
So first of all, I think it's a mistake to seek to divorce the threat of lawfare from the kinetic. I think we have seen ample evidence over the course of the last 15 months that Israel's ability to defend itself has been undeniably impacted by the lawfare initiatives that we've seen, and they kind of work both ways. Hamas's only objective since starting this war was to survive, and its means of seeking to do that was simply applying pressure on Israel and the international community so that Israel would cease its lawful self-defense. And we have seen that in the context of the rhetoric. Even Antony Blinken has at least been honest enough to acknowledge the immense damage that has been done every time the rhetoric of the United States indicated that it was being hard on Israel, that it was simply encouraging Hamas. In the context of that interview that he gave, it was to walk away from negotiations, but we have seen it at every juncture of Hamas's activity militarily, its terror armies that it has been leveraging against Israel. And when we consider that, when I speak to friends of mine who've been on the ground in Gaza, and I've said over the course of this year, how's the war going? So often the response I've had is not bad, considering we have both hands tied behind our back. Why is it that my friends who are putting their lives on the line have both hands tied behind their back? I think it is because of this eighth front. It is because of the impact that the lawfare campaign is having on Israel's ability to defend itself, be it an arms embargo that the UK has imposed on 30 arms licenses on an entirely unlawful basis, because there is no nexus between the concerns that the UK has raised, unfounded as they may be, the concerns that the UK has raised on aid and on detention and the arms that it has embargoed, despite saying that there are in fact no concerns that the UK has identified in terms of international humanitarian law so far as targeting and proportionality is concerned. Incidentally, that is the same conclusion that the United States has drawn. And these are two entities that Israel has shared considerable sensitive information and intelligence with, pertaining to its targeting and proportionality assessments. And that is pretty indicative of the fact that it's correct. What other independent experts, such as Richard Kemp, such as John Spencer, have been consistently saying, that no other army has gone so far as Israel to prevent civilian casualties, to conduct precise strikes, to exercise precaution, keeping civilian casualties down to an all-time low in the context of urban armed conflict. So in that context, I think it's extremely important to be mindful of the impact that lawfare and failing to properly address it and push back on these falsehoods necessarily has on the kinetic. That's not in any way to take away from the incredible military achievements of the last year. The difference, I know it's difficult because we're all living in the moment, but to pause and take stock on the position today vis-a-vis Hamas, Palestinian Islamic Jihad, vis-a-vis Hezbollah, even the Houthis in Yemen, and of course Iran, for whom they are all proxies, to take stock of the incredible military achievement that Israel has achieved at great sacrifice, and the additional 5 soldiers who have been killed that were announced at the beginning of this webinar, should never have had to be the case. Were Israel not having to fight with both hands tied behind its back because of the international legal war that is being waged against it, they might not have had to make that sacrifice. And the longer that we put our heads in the sand, the longer that this shum attitude is maintained by, unfortunately, the state of Israel, the longer that we say, oh, this is too complicated or too difficult, or we might be right, but actually explaining our position in a way that is consumable by the international media on these technical legal issues is simply not feasible. The longer that we continue seemingly to acknowledge some kind of defeat on these points, even though the law and the facts are entirely on our side, the harder the kinetic is going to continue to be. And it breaks my heart that we are failing, I'm afraid. I will say it in this context, that we are failing so profoundly on the legal battlefield because it is so intimately connected. It is inextricably linked with the military battlefield.
So to that then, I'm going to ask John Mirish's question, and thank you for joining us, John, who is from LA. So I hope you're safe and sound asking this question. The legislation before the U.S. Congress right now to sanction the ICC, does legislation like that work? How do you think this should be something other countries engage in, and to what extent or why do you think that'll work? Just the mere pressure would force. How do you think it would work?
In a word, yes. No, I appreciate there's a little way for this legislation to go. I note that under the previous Trump administration, in fact, ICC officials were sanctioned by executive order, and I would fully expect some form of that post the 20th of January, hopefully on the 20th of January. I don't know if I can be quite so demanding. Perhaps some of your colleagues, Mark, may be able to increase the pressure and the urgency on that front. But plainly, American approaches to the ICC in this vein before did have an effect. The ICC dropped its misguided and unlawful investigation into United States servicemen in Afghanistan. And I think in the context of what we're seeing here, every pressure needs to be brought to bear to bring the court in line with its legal parameters and the appropriate exercise of its jurisdiction. Let me make it clear, I'm not suggesting that there needs to be political influence here to affect what is a legitimate legal process. Quite the contrary. It is because this process has strayed completely away from the legal and into the realm of the political that tough action needs to be taken, and sanctioning the officials at the court and their associates and anyone else. And I appreciate it doesn't apply to Americans. It applies to foreign persons, but there are a number of these so-called experts who provided a sign-off to Karim Khan's application. That in and of itself is unprecedented. It is unprecedented that the prosecutor would publicly would go on Christian Amanpour and give a press release and give a public announcement of the issuance of an application for arrest warrants. Normally, these are done in secret so that the subjects of these applications do not know that there is a warrant out for their arrest and they may be picked up when they go and travel. There's every indication from the unprecedented, unique approach that the court has adopted here that they had no intention of actually arresting the Prime Minister or former Defense Minister of the State of Israel. Otherwise, they wouldn't have made such a song and dance about it. This was all about posturing. It was all about the PR side of things. And that merits a robust response by the leader of the free world. I hope that after the US takes this approach, others will follow. And it is frequently the case that one sees, one state leading the way and then others feeling perhaps more comfortable in doing what should be natural to those that support the rule of law and calling the ICC out on this approach. Vis-a-vis the ICJ, there are very important similar approaches that need to be made. I mean, states are in a position to make submissions. They are also in a position to intervene. They are in a position to also bring cases against other states. I mean, Iran is the primary culprit for real genocide for decades, to the extent that, no one's providing the kind of support and inducement, perhaps, that we're hearing has been provided to South Africa to bring this case against Israel. No one's necessarily providing that sort of inducement to bring a case against Iran. In fact, quite the contrary. But this all necessarily sort of plays into the dynamics that we're witnessing and the more pressure that can be brought to bear to ensure that international law is actually upheld, the better.
One more question. I'm going to group a couple of people have asked similar questions, so I'm going to group them together, and then I'm going to turn it over to Tom Flesch, our chairman of the board, to say a few closing remarks. Could you talk about the Hein Rajab Foundation, their work, as well as sort of the derivative response, which is now you had 12 cases filed in 12 different countries in potential investigations into IDF soldiers. Could you comment on that, please?
Sure. Unfortunately, this is not a surprise. It is not in any way unexpected. There are groups of Palestinian lawyers, sometimes organized in the case that you've raised, and sometimes more ad hoc, that have been fundraising and collecting names, identities of Israeli soldiers, dual nationals occasionally, and are ostensibly preparing arrest warrant applications against them. This is very country by country specific, and it is dependent on the laws in each of the respective jurisdictions. I can tell you that in the UK, there were a spate of applications for arrest for, our audience may recall, Tzipi Livni, Ehud Barak, around 2009-10. And a stop was put to that on the basis that a provision was introduced by the government at the time saying that any application of that nature for an arrest warrant, for supposed war crimes, required consent from the Director of Public Prosecutions before it could be brought. That exists still today. Who knows if with this changing and this developing, this tsunami of misinformation, we may very much get to a position where, there's Crown Prosecution Service guidance on this in terms of whether or not the evidence is credible, whether or not a prosecution is likely to be successful. That all, in this particular instance, could arguably become a sort of political assessment and a consideration based on, what it is that the BBC is reporting, and what the received wisdom has now ultimately become. And I can see that reflected in many other jurisdictions, many other countries besides. It is a significant problem. The best way of dealing with this. I'm going to give you the typical lawyer's answer of, it depends. It is going to be case specific. But I can tell you, having been on the ground in Gaza, I was there in September. I went in with the 162nd Division only a few days after they recovered the 6 hostages who were murdered in the tunnel. I went in with military experts from around the world, from generals, majors, and I should say an enormous thank you to ELNET that facilitated this trip and was pivotal in organising it, along with Daniel Burke and Vladimir Beaumont from the UK. And Joan was on the ground there with us. I think everything that we witnessed with our own eyes in terms of how the IDF operates there, in terms of the challenges that are being faced with the tunnels under the Egyptian border. We went along the Philadelphia corridor. We went into Rafah, where we saw every single civilian house booby-trapped. All of this context is, of course, absent from the sorts of applications that we have seen, and I'm afraid we will continue to see against individual Israelis. And we can only try and combat those on a case-by-case basis when they arise, or, and this is a sort of aspect of preemption, trying to get whatever the state and judicial authorities are in the relevant jurisdictions on board, trying to educate and ensure that they are at least familiar with the type of misinformation that underpins these applications and the realities of Israel's conduct in the Gaza Strip. And that kind of information I know comes out of ELNET, I know comes out of the high-level military group. UKLFI has been providing a great deal of it in terms of the legal analysis, the analysis of casualty figures. We've just seen more falsehoods put forward by the Lancet publication. Countering those in the public arena is going to be supremely important, really significant to being able to hit these aspects on the head. So perhaps ending on a slightly lighter, more positive note, and a deep thanks to ELNET and to Joan and her colleagues who were on the ground facilitating that. And I know the incredibly important work that so many organizations like ELNET, like UKLFI are doing to try and get the truth out. I do hope ultimately that the truth will out and that we will ultimately be victorious through shining a light on the realities, both in terms of the facts and the law.
Thank you, Natasha. And I apologize for everybody. I just asked Randy to put in the chat the month debate where Natasha and Douglas Murray took on Mehdi Hassan and Gideon Levy. It is a tour de force and a masterclass on a number of levels, and I thought all of you would appreciate watching it if you haven't done so. Now I'd like to turn it over to Tom Flesch.
Thank you. Can you hear me?
Yes.
Thank you so much. Mark, another superb job presenting today. And Natasha, thank you so much for your words of wisdom, with deep thought, very emotional. We're suffering here a lot in Los Angeles right now. But through all the suffering, it resonates in my mind that in our Jewish tradition, we have gone through persecution, we have gone through destruction many, many times, too many times, and we always prevail. And notwithstanding breakdowns in government, notwithstanding breakdowns in our infrastructures, it's our people that are resilient. And I see it here every single day, not just Jewish people, but the community joining together, looking out for each other. And it's such a Jewish value. And I say to you that those who call the United States of America or Israel apartheid, genocidal, and that they're not doing enough to protect the innocent Gazans from attack when they are in fact put in the line of fire. The story has to be told in its totality, not just pieces. And to defend against something like this is a horrendous thing to do. I applaud the efforts that are being made, and I hope we're doing more efforts, because the Jewish tradition, the tradition of these fine people that rise for justice and right, for freedom and democracy will prevail, and it's prevailing here in our streets today. Everybody's out to protect each other. Our government had a colossal failure in preparing for something like this. There is no question about it, and there will be consequences, but it is a moment to see how the community gathers together. And I hope in Israel, the community gathers together for the common good interest, which we all intend to have a better life for everybody. And this casualties of war is just horrible. But I just hope the work that you do spreads more. And there's there's another encouraging thing too, and that is a lot of our viewers that are regulars on this Monday morning briefing are not with us today, because most likely it's not that they're not alive, they're alive, but they don't have a home, they don't have anywhere to go, and they're all finding some place to be. And so we miss them not being with us. Our prayers are with them, and we hope that they can get back in some semblance of a routine sooner than later. But thank you to all of you for the hard work you do to inspire our going forward basis with resilience and a positive outlook, and we will not be defeated.
Thank you for those words, Tom. Natasha, again, thank you for joining us, and everybody, have a very good day. Bye,
Thank you.
everybody.